conviction, the same is delayed by 22 days.
22 days.
My lord. IA number 15528.
Delay condoned. लिखिए श्री श्याम
Anshul Shrivastava.
श्री अंशुल
Shrivastava.
श्रीवास्तव फॉर द अपीलेंट अगेंस्ट कन्विक्शन है ना
My lord.
श्री मुकेश कुमावत अब डिले कंडोन कर देते हैं अगेंस्ट कन्विक्शन है 22 डेज का है हार्ड ऑन आइए 15528 of 2022 which is an application for condonation of delay full stop. The present appeal is filed to against the order of conviction and sentence full stop. There is delay of 22 days in filing the present appeal. Considering the grounds mentioned in the application, the same is allowed. The delay in filing the appeal is condoned. Full stop. Appeal is admit भी कर लेते हैं record. Appeal is admitted for final hearing. The record of the trial court be requisitioned. Yes. Yes.
There is appeal against conviction and also pending
Delay.
higher delay.
How much is the delay?
98 days.
98. वही सेम ऑर्डर कन्विक्शन के खिलाफ है ना श्री
विजय शर्मा
श्री विजय शर्मा फॉर द अपीलेंट श्री मुकेश कुमावत आइए चेंज हो जाएगी 15445 of 2022 for condonation of delay of 98 days condoned है ना सेम ऑर्डर yes
Praying for 2 weeks time to argue the matter because the matter has to be argued by senior advocate Shri Jhelawat.
yes लिखिए श्री प्रत्युष
My lord, Pratyush.
मिश्रा for the appellant श्री चेतन दवे for the respondent at the request of counsel for the appellant list after 4 weeks. क्या विड्रॉवल
जी मैम
लिखिए श्री अनिकेत नायक फॉर द अपीलेंट श्री मुकेश कुमावत गवर्नमेंट एडवोकेट फॉर द रिस्पोंडेंट स्टेट श्री वीके जैन सीनियर काउंसिल विथ एमएस पूर्वा जैन वैशाली जैन फॉर द रिस्पोंडेंट नंबर 2 लिखिए यस श्री जैन सीनियर काउंसिल विद श्री कुशाग्र जैन फॉर द रिस्पोंडेंट नंबर 3 4 and 5 कर दीजिए लिखिए हार्ड ऑन आइए 8423 of 2022 which is an application for withdrawal of the appeal. Okay, for the grounds stated in the application, the same is allowed. Appeal is dismissed as withdrawn.
My lord, I have sought also the liberty to repeat it in case the occasion arises.
Writ appeal में writ appeal में liberty कैसे मिलेगी?
नहीं तो for repeating the petition as well, my lord. I have stated a reason for withdrawal. I have stated a reason for withdrawal, my lord. If that liberty is not to be granted, my lord, then I may be permitted to take instructions from the client. I will argue on merits in that case, my lord. Because, my lord, here my lord, I have come against the order wherein I have not been found that I have the locus to challenge the impugned action, my lord.
Yes.
And I was challenging on the account that I have been conferred with the locus on account of being the counsellor of the council. Now it happened so incidentally with the passage of the time, my lord, I have no more remained a counsellor because elections have taken place. So therefore, my lord, since at the moment, my lord, I do not have locus, therefore I am withdrawing this petition.
सर ऐसा है आपका ये कहना है कि आपने कॉर्पोरेशन में एप्लीकेशन लगाई है. They have basically challenged annexure P11 which is an order passed by the state government. petition has been dismissed on the ground of locus standi. And that the subject matter of this writ appeal is
Yes.
the order passed by the learned single judge, whereby the
Yeah.
locus standi has been impugned in this order, madam. So where is the question? If your lordship would go through the provisions of order 23, this can't be any ground for granting permission, and it is always for the court, my lord, to grant the permission or not to grant.
So in case if they object for such liberty, my lord, so it may kindly be adjourned. Let me take the instructions. I will argue on merits in that case, my lord. If they object for liberty,
Yes.
As far as I am concerned, I have no objection to grant liberty, my lord. And
Yes.
he is justified in asking for liberty.
and that is the prayer, my lord, because the instructions for withdrawal, the instructions for withdrawal on behalf of appellant is subject to grant of liberty. If my lords even
What
are not,
was the petition about?
my lord, we have challenged an action, my lord, which is an order passed by the state government. Now, my lord, that action of passing of that order
Okay, state government passed what order?
my lord, the resolution passed by the municipal council has been overturned by the state government. And the resolution which was passed by the municipal council, I was the councillor there.
What was the resolution?
My lord, for cancellation of lease.
So how you have got the locus?
Because I was the councillor and I was the person who has placed this agenda in the resolution meeting, my lord.
Challenging the
My lord,
same order at
that
PIA
is
was
that
filed
is
and
the
that
merit.
was also
That
dismissed
is
by
the
the
merit
Honorable
of the
Court.
petition and appeal, my lord. That is the merit of the petition and appeal. So in case if they object, my lord, let me take the instructions. My lords may kindly keep it in a week.
Yes. So
We will
better
argue
that
on
you
merits
keep
then.
it. You seek instructions.
Yes, my
because in a writ appeal, liberty means the overriding the order passed by the single bench.
No, for repeating the appeal only, my lord. From the stage where I am leaving this litigation. Had it been a case, my lord, where I am saying that I will bring a fresh petition in supersession of the order of the writ court, it would have been a different thing. I would
अपील की लिबर्टी
अपील की liberty
हाँ,
तो दे
अपील की
सकते
liberty
हैं।
है।
आपने इसमें पिटीशन का लिखा
नहीं वो शायद
हाँ,
गलती से लिख गया है क्योंकि विड्रॉ अपील कर रहे हैं
वही
तो।
that's why
जी,
I
जी।
said कि that would amount लिखे वो जहाँ लिख रहे थे ना heard on application for withdrawal of the appeal considering इतने appeal is dismissed as withdrawn with liberty to revive the writ appeal in case if the occasion arises with the aforesaid liberty the writ appeal is dismissed as withdrawn.
Obliged, ma'am.
Yes. Yes.
In this case,
Yes, Mr. Sarma.
the matter is with respect to the counting of the service of the respondent and also for the with respect to the applicability of the circular dated 16/7/2007 of Sthai Karmi Yojana, Lordship. Lordship, kindly consider the order passed by the Honorable Single Bench.
Notices have already been issued.
Yes, Lordship. And the application
Served
for...
on.
Yes, sir.
Whether served. तो सर्व हो गया है महेश कुमार चौधरी who was appearing for him in the
Mahesh Chaudhary.
Mahesh Chaudhary.
Yes, Lord.
ये आपने
On the last date, this Honorable
just a
Court...
minute इसमें सर्विस महेश चौधरी को दिखा रहे हैं who is the respondent
Dinesh, son of Gyasi Ram.
Shri Mahesh Kumar Chaudhary, advocate served.
Yes.
He was appearing for Dinesh.
Yes, Dinesh. In the writ
आज
court.
उनका नाम नहीं आया क्या?
Sir, आया उनका. So, उनके Mahesh Chaudhary is coming from Ujjain actually.
Ujjain.
So, on the last date, I think Miss Kirti Patvardhan appear on behalf of Shri Mahesh Chaudhary.
None but respondent goes served. Is the case as prayed is awaited as prayed by counsel for the last date पे appearance तो नहीं डली है कितना डिले कितना है
68 days का है Lordship.
लिखिए श्री शर्मा गवर्नमेंट एडवोकेट for the appellant, none for the respondent, though served and represented by counsel, held on IA 1210 of 2020 for condolation of delay. Full stop. It is stated that after passing of the order by the learned single judge, an opinion in the matter was sought from the office of the Advocate General Indore, and the said opinion was given on 21/10/2019. Thereafter, the file was sent to the higher authorities for seeking permission to file the writ appeal. Full stop. The department, vide its communication dated 3/2/2020, granted the permission to file the present appeal. Full stop. And thereafter the appeal has been filed. Thus, the delay is caused due to completion of the official formalities in seeking legal opinion and permission for filing appeal. Full stop. After taking into consideration the aforesaid assertions made in the application, supported by an affidavit, and in absence of any opposition to the said application, the same is allowed. The delay of 68 days in filing the appeal is condoned. List the matter for hearing on admission after 4 weeks. Yes,
Lord, I'm praying for a week's time, Lord, to take further instructions. Will God
Virtually, the appeal has rendered infructuous owing to the fact that the transfer fee has already been deposited even before the filing of the suit.
that I have mentioned in my appeal also, Lord. But as far as the other documents are concerned, Lord, I need to take further instructions.
लिखिए श्री ऋषिराज त्रिवेदी, learned counsel for the appellant, MS Mini Ravindran for the respondent. At the request, counsel for the appellant placed for time to seek instructions regarding continuation of the appeal. List the matter after. अब सब वेकेशन के बाद जाते हैं. List after 4 weeks. Yes. Yes, Mr. Kumawar. लिखिए श्री. Yes.
Three applications can be disposed. IA number 484 of 2022 for ignoring defect. That will be allowed, madam.
Yes.
IA number 3460 of 2022 again for ignoring for defect. That will also be allowed. IA number 282 of 2022.
Arjun.
These three applications can be disputed safely. So,
And there is also delay.
substantial delay, more than 5 years.
लिखिए श्री मुकेश कुमावत, गवर्नमेंट एडवोकेट फॉर द appellant, श्री VK जैन, सीनियर काउंसिल, assisted by श्री वैभव जैन for the respondent. Number 1, heard on IA 484 of 2022 and IA 3640 of 3460 of 2022 for ignoring the defects. For the reasons stated in the application, the same is allowed. the office objection is directed to be ignored. लिखिए counsel for the respondent.
IA number 282 of 2022 for early hearing. That you also उसको इंस्ट्रक्टर से अभी लगेगी.
Yes, yes. Because since the matter has been taken up by this court and therefore the IA 282 of 2022 for urgent hearing stands disposed of as no order is required to be passed on the said application. आप कंडोनेशन का जवाब देना चाहिए. दे दिया है.
डिले में काइंडली भी कंडोन
कितना वो सब्सटेंस तो दैट
सो माय लॉर्ड में काइंडली लिस्ट माय लॉर्ड दिस केस माय लॉर्ड नेक्स्ट वीक में.
नेक्स्ट वीक यू वांट. अब आफ्टर 1 वीक कर देते हैं. वी डोंट नो वेदर द बेंच विल बी कॉन्स्टिट्यूटेड इन द नेक्स्ट वीक एट द रिक्वेस्ट ऑफ काउंसिल फॉर द स्टेट
डिले
हियरिंग.
कंडोन करने की प्रेयर इसलिए करा तो साहब को सुनने का मौका मिलेगा.
नहीं नहीं
तैयार हूँ बहस करने के लिए. अगर आप तैयार हैं
तो डिले कंडोन होने के बाद ही हो पाएगी.
नहीं डिले पे बहस करना है.
5 साल का डिले.
5 साल का डिले.
नेक्स्ट वीक में
hearing on IA 283 of 2022 and IA 284 of 2022 is adjourned at the request of counsel for the state, counsel for the appellant for period of 1 week. तैयार रहिए. इसमें there are number of judgments now against the state. No leniency can be shown to
I have
the,
also brought my lord one judgment of Supreme Court.
I have also delivered a judgment citing judgments dismissing a state appeal.
मनोज 2017 का जजमेंट है रेड कोर्ट का. 2017 के बाद से लगातार इनके हम कह रहे हैं कि आप इसको कंप्लाई करें और 2021 तक ये कंप्लाई नहीं कर रहे. बोला हमको अपील फाइल करना, हमको अपील फाइल करना.
आने दीजिए मिस्टर कुमावत. You will get an opportunity to hear Mr. Jain.
जब कंटेम्प्ट फाइल किया तो एक अपील.
Yes.
मतलब टाइम नहीं तो मतलब नेक्स्ट वीक आज की डिलिस्टिंग देंगे.
Hmm?
आज की डिलिस्टिंग देंगे मतलब
Delisting है.
आफ्टर अ वीक.
लिखिए श्री मनोज मानव for the appellant, श्री शर्मा GA for the state, श्री आपका क्या नाम है?
राहुल पांचाल.
Shri Rahul Panchal for the respondent number 6 at the request of counsel for the respondent number 6. Case is adjourned for 1 week.
आफ्टर ए वीक कर दे मालूम.
After a week, for 1 week कर दिया.
तो ये प्रोसीडिंग में आ जाएगा तो इट विल बी लिस्टेड मालूम.
List after a week. Yes.
The reply is awaited from the side of the respondents. I think some for private respondents also wakalatnama has been filed. That is the
Yes.
case, I guess.
The notices were not issued in this regard. An interim relief has been granted in favor of the appellant.
The appeal is barred by 80 days.
But that has been condoned, my lord, by the order dated
It's
16/9/22.
hereby condoned.
Ji.
No third party right will be created.
My lord, in this case, when this order was passed, already third party rights have been created. I am the purchaser in auction from a bank.
So that will not affect.
But subsequent
That is
third
for
party right
future.
will not be created, my lords.
I don't have any objection with
You-
respect to that, but since I have
So what is, it is listed for today for appeal is already admitted
No, my lords.
no, my lord.
for stay.
My lords.
This is a recovery case against the decree passed. Execution has been
So,
done.
Mr. Agarwal,
My lord.
you want to argue today or
On any date, my lords. If they want to file reply, my lord, they can to the
you
legal
want
issue,
to
they
file
will-
reply?
My lord.
Sri Akshat Agarwal, Learned Counsel for the appellant. Sri Sharma, GA for the respondent state. Sri Ashutosh Nimgaonkar for the respondent number 5.
5 and 6.
5 and 6, comma, at the request of counsel for the parties कर दें, है ना? List after 1 week, interim order to continue.
17. the reply has to be filed, my lord, by the bank. And my lord, there is the issue that RBI is a party and he is the basically, I think so we would agree, because on one of the occasions the
How
bank
much
has
is the delay?
Lord, delay is basically 12 days, my lords. The order is dated 15 days, my lords.
15 days.
My lords,
delay.
the order is dated 7/5/22, which has been uploaded on 31st of May 2022.
Yes.
But if my lord would see the order, the last page itself says it has been uploaded on 31st of.
My lord, I'll file a reply to this.
No issue.
One time.
I'll file a
Sri Akshat Agrawal, learned counsel for the petitioner, Sri Abhinav Dhanotkar,
1 and 2.
for the respondents 1 and 2,
If my lords,
counsel for the respondents 1 and 2, praise for and is granted 2 weeks time to file reply, interim order, list after 2 weeks, interim order to continue.
if my lords deems fit, my lord, Reserve Bank of India is a necessary party, notice may be issued, because we had sought to Chitle Sahab, they said that he is not.
After hearing, if
As my lords are pleased, because the issue is not with regard to RBI guideline. So until and unless they will be heard, there
no,
would
they were not party before this.
they were, my lords. They were.
I filed the reply, and after reply it has been heard finally, my lord.
As my lords are pleased,
No
but
requirement of acting, my lord.
because the clarification of
ठीक
RBI
है,
guidelines are
we will
required.
issue
As-
notice later.
As my lords are pleased.
Yes.
Obliged.
नहीं है. None for the petitioner Sri Sharma, government advocate for the respondent state. Case is adjourned. Yes, same order 19, same order 20. Just after 5 minutes.
Well, this is an appeal under section 37 of Arbitration Act. Well, there is another identical arbitration appeal, my lord, number 112 of 22. May I pray for tagging this present appeal with that?
With that,
Ji.
लिखिए श्री अनिकेत नायक, learned counsel for the appellant. At the request of counsel for the appellant, list the present matter with arbitration appeal 1112 of 2022. कब yes.
The present petition has been filed under Article 227 challenging the impugned order passed by the learned Industrial Tribunal dated 23/2022, whereby the claims filed by the respondent number 1 union has been allowed, your lordship. And the ground for challenge under this present petition is that the learned Industrial Tribunal has answered the question of references beyond the scope of the question of references. And
What
moreover,
was
yes, your lordship. The issue before the learned tribunal was that, your lordship, pertaining to the overtime which was paid to the.
Where is the reference?
Reference at page number 33. The order is at page number 20, your lordship.
33
is the order of the reference.
Yes.
And the impugned order is at page number 20.
क्या अभी तक
The respondent union is representing, lordship, the drivers who are running ambulances throughout the state of Madhya Pradesh, which is and the employer of those drivers is the present petitioner, your lordship.
Yes.
Now the issue pertaining to the overtime period came up, and therefore the dispute was referred to the Senate Industrial Tribunal with pertaining to the 4-hour period apart from the service period of 8 hours. That is from 8 hours till 12 hours, your lordship. Now they have submitted that they have been working for 12 hours, which has been specifically denied by us and has been recorded by the Honorable Tribunal. That we have specifically denied the plea of the respondent union pertaining to, yes, your lordship. And thereafter, and the Honorable Tribunal has decided that they are eligible for the overtime period under the Minimum of the Wages Act. However, they have completely disregarded the rules of the Minimum Wages Act, in which the period for the spread over time is being mentioned. Now, spread over time is, your lordship, it is the time for which can be elongated. Suppose it is 8 hours, then it can be elongated up to 12 hours, and just that it will include all the intervals which have been given to the employees.
Yes.
So that interval period will also amount in the spread over time. That has been completely disregarded, which is the finding of the Honorable Tribunal is at page number 32.
What the tribunal held?
Yes, lordship. Page number 32 may kindly be seen. Just read out from the para 21. द्वितीय पक्ष के साक्षी अमित पातकी का कहना है कि 108 एम्बुलेंस में कार्यरत स्टाफ को साप्ताहिक अवकाश का लाभ दिया जाता है। प्रथम पक्ष के साक्षी रामस्वरूप परमार एवं नुपेंद्र तिवारी ने अपने मुख्य परीक्षण में यह व्यक्त किया है कि उनसे सप्ताह में 72 घंटे की ड्यूटी ली जाती है, जिससे यह अवधारणा बनती है कि प्रथम पक्ष के कामगारों को साप्ताहिक अवकाश प्रदान किया जाता है। इसलिए प्रतिदिन 12 घंटे के हिसाब से उनके ड्यूटी के घंटे सप्ताह में 72 हो रहे हैं। अतः यह प्रमाणित है कि प्रथम पक्ष कामगारों को साप्ताहिक अवकाश का लाभ प्राप्त हो रहा है। Now, the finding pertaining to the 12 hours has come upon only on the basis of the statements made by them, and no evidence pertaining to that has been submitted by them.
Yes.
Now, thereafter, in para number
There was
20,
denial to that.
yes, there was denial to that. It has also come on the record, Your Lordship. We have denied it.
Yes.
And however, if it is the fact that the 12 hours has to be considered, then the exceeding time about 8 hours has to be treated as the spread over time as per the Minimum Wages Act rules also, and as per the Motor Transport Workers Act also. That was our contention. And in para number 22, the third may kindly be seen, Your Lordship.
Yes.
108 एम्बुलेंस में कार्यरत कर्मकार न्यूनतम मजदूरी भुगतान अधिनियम 1948 की धारा 14 सपठित न्यूनतम मजदूरी अधिनियम रूल्स के अनुसार सामान्य कार्य 8 घंटे से अधिक की अवधि के लिए प्रत्येक घंटे हेतु अधिनियम के अंतर्गत निर्धारित दर से ओवरटाइम राशि पाने के अधिकारी है। प्रथम पक्ष के कामगारों को वर्तमान में साप्ताहिक अवकाश का लाभ प्राप्त हो रहा है, अतः इसके संबंध में कोई निर्देश दिए जाने की आवश्यकता नहीं है। Lordship, this particular point in which if Lordship have seen the reference order was also pertaining to the spread over time. So particularly with the concern of the spread over time, no finding has been given by the Honorable Court. However, if a Lordship may kindly peruse the Rule 25 of the minimum wages rules 1948, it's been quoted at page number 14, Your Lordship. Page number 14 of the petition. It particularly specifies with pertain to the spread over time.
Yes.
Rule 25, Your Lordship. Number of hours which shall constitute normal working days. The number of hours which shall constitute a normal working days shall be A in the case of an adult 9 hours. Then the subclause 2, Your Lordship. The working day of an adult worker shall be also arranged that inclusive of the intervals for the rest, if any, it shall not spread over more than 12 hours on any day or such longer periods as the government may notify by general or special. So there is no finding pertaining to
There
the
is no
spread.
judgment by this court regarding the terms and conditions of the appointment or engagement of these ambulance employees.
Lordship, there was a
I
judgment.
remember had come
Yes.
also before the division bench at
Lordship,
principal
not the
bench
division,
Jabalpur.
there is the learned industrial tribunal has relied upon the judgment passed by the single bench of the honorable court, which is at page number 56. Now, in that the issue was, Your Lordship, whether the motor transport rules workers act will be applicable to the present employees who are working as a driver in the ambulance or the minimum wages act. So in that it has been held that the minimum wages act will be applicable. That's it. Only pertaining to
Just
that.
checked one judgment when the advertisement was issued for these ambulance employees by NRHM.
Yes, Lord.
Then the writ petition came for challenging that. Then this court said कि decide their terms and conditions to the NRHM in terms of the Minimum Wages Act.
Yes, Lordship. Now, even if it is considered that the minimum wages act is applicable to the respondents,
देखिए श्री प्रखर मोहन करपे for the petitioner in the instant petition, a challenge has been made to the award passed by the industrial tribunal, whereby the claim of the respondent workers union towards overtime and respect of spread over period has been allowed. Counsel for the petitioner submits that the aforesaid award is beyond the terms of the reference. Issue notice to the respondents on payment on admission as well as on IA 8461 of 2022 on payment of PF within 7 working days by both modes, returnable within 4 weeks till the next date of hearing. The operation of the impugned award annexure P1 dated 5/23 8 2022 shall remain in state. इसीलिए दोनों डाल दिया प्रोनाउंसमेंट Yes, Mr. Sarman.
in this case, the point is to be decided whether the respondent is a daily wager or contractual, Lordship. Our submission is that he is a contractual, since the benefit of the Sthai Karmi Yojana will not be extended to the respondent, Lordship. Now, Lordship, please to consider that his appointment order dated 28/5/1999, Lordship. Annexure P1.
What the single judge had?
Kindly page number 17 to 18, Lordship, the order. The honorable single bench said by that the circular dated 7/10/2016 will be applicable to the respondent, and directed the petitioner is disposed of with the direction to the respondent to classify the petitioner as skilled permanent employee in the pay scale of rupees 5,000, 8,000 within a period of 1 month, Lordship. Now, Lordship, please to consider the appointment order at page number 28.
He was a contract employee.
Contract employee.
कॉन्ट्रैक्ट नहीं आप पूरा आधा नहीं पढ़ रहे
नहीं, इनका submission इनका. Where have you argued that he is a contract employee?
Now, Lordship, please to consider at page number 28, which is the appointment order of the respondent, Lordship. And thereafter, Lordship, twice the case has been considered by the appellant. Before coming to the consideration of the representation twice, I would like to draw Lordship kind attention at page number 28, which is the appointment order of the petitioner.
Mr. Sharma,
yes.
Read page 17.
70.
Last. Respondents have filed a reply.
Yes. Respondents have filed a reply by submitting that the case of the petitioner is to be considered in the light of the circular dated 7/10/16 by which the state government has directed all government employees to classify the daily wager as permanent employee in respective category.
ये तो आप ही का केस था कि
इसका रिप्लाई में दोनों जगह है, पैरा 70 में भी और पैरा 21 भी जगह.
तो आपके रिप्लाई के आधार पे तो डिस्पोज आप कर दिए.
कंट्री तो रिप्लाई आर्ग्यू करता है.
नहीं, ऐसा नहीं है.
आप पैरा 70
Now, Lordship,
let him argue his appeal.
Now, Lordship, consider page number 53. 53 जो हमारा रिप्लाई है सर, वो कंसीडर करें पेज नंबर 6 एंड 9, पैरा नंबर 6 एंड 9.
Reply is at page
53. 53 पे है सर. वो सबमिशन, इट माइट बी पॉसिबल दैट वो सबमिशंस पूरे नहीं आ पाए हैं उसमें. तो पैरा नंबर 6 एंड पैरा नंबर 9 ऑफ आवर रिप्लाई इज रिलेवेंट, व्हिच इज एट पेज नंबर 53. मे आई रीड?
यस.
ये कि याचिकाकर्ता की संविदा नियुक्ति को वर्ष 2001 में ही समाप्त किया जा चुका था. द रेस्पोंडेंट वाज अपॉइंटेड ऑन 28/5/99 सर. इसके बाद है ये कि याचिकाकर्ता की संविदा नियुक्ति को वर्ष 2001 में ही समाप्त किया जा चुका तथा वर्ष 2002 से याचिकाकर्ता कार्यों के घंटों के आधार पर भुगतान प्राप्त कर रहे हैं. याचिकाकर्ता की नियुक्ति किसी स्वीकृत रिक्त पद के विरुद्ध नहीं हुई है. याचिकाकर्ता के द्वारा P125 इत्यादि के दस्तावेज प्रस्तुत कर यह दर्शाने का प्रयास किया गया है कि उसकी नियुक्ति स्वीकृत रिक्त पदों के विरुद्ध हुई है, किंतु 1, 2, 5 के दस्तावेज मात्र प्रस्ताव हैं और इसके आधार पर कोई पद स्वीकृत नहीं किए गए. स्वीकृत रिक्त पदों पर नियुक्ति हेतु निर्धारित चयन प्रक्रिया का पालन किया जाता है. याचिकाकर्ता के द्वारा P6 पर जो आदेश पारित किया गया है, उक्त आदेश से दर्शाने का प्रयास किया है कि याचिकाकर्ता की नियुक्ति समकक्ष वेतनमान वाले रिक्त पद पर कंप्यूटर ऑपरेटर के विरुद्ध कंप्यूटर ऑपरेटर के संविदा के पद पर 1 वर्ष के लिए की गई है, किंतु उक्त नियुक्ति को भी 1 वर्ष पश्चात निरस्त कर दिया गया है. इसके उपरांत से याचिकाकर्ता को कार्यों के घंटों के आधार पर नियुक्त किया गया है. नाउ लॉर्डशिप प्लीज टू कंसीडर.
नहीं वो आपका
आप पढ़ रहे हो, उसका पैरा 5 भी देख लेना उसी में. आप जो आप कह रहे हैं
नहीं, मैं
उसी का पैरा 5 भी देख ले.
मैं पढ़ देता हूँ ना, पूरा रिप्लाई पढ़ देता हूँ.
लास्ट 5 है. उसके उपरांत मानव याचिका की नियुक्ति 30/1 को समाप्त कर दी गई है, कॉन्ट्रेक्चुअल अपॉइंटमेंट में रहेगा, खत्म हो गया।
ये कि
उसके बाद
पी-
याचिका
पहले पढ़ते ये कि P4 पर याचिकाकर्ता को संविदा पर नियुक्ति आदेश दिनांक
कहाँ पढ़ रहे हैं, विच पैरा?
सर पैरा नंबर 5 जो ये कह रहे हैं वो भी मैं पढ़ देता हूँ सर, उसमें भी ऐसा नहीं आया है। ये कि P5 पर याचिकाकर्ता को का संविदा पर नियुक्ति आदेश दिनांक 28/5/99 है, पर प्रथम मुख्य वन रक्षक के निर्देश दिनांक 14/6/2000 की प्रति प्रस्तुत की गई है, जिसमें संविदा आधार पर नियुक्त कंप्यूटर कर्मियों की सेवाएं निरंतर रखने के निर्देश हैं। P6 पर याचिकाकर्ता का दिनांक 30/6/2000 का संविदा नियुक्ति आदेश है, जो कि 1 वर्ष के लिए है। P7 का संविदा नियुक्ति आदेश भी 1 वर्ष के लिए है। इसके उपरांत याचिकाकर्ता की नियुक्ति दिनांक 30/1/2001 से समाप्त कर दी गई है।
कॉन्ट्रेक्चुअल अपॉइंटमेंट खत्म हो गया।
और याचिकाकर्ता को श्रम आयुक्त मध्य प्रदेश इंदौर द्वारा दिनांक 1/4/1 से 30/9/1 तक कुशल एवं अकुशल श्रमिकों के मासिक एवं वेतन दैनिक वेतन की निर्धारित दरों पर कार्य करने हेतु याचिकाकर्ता को उसके कार्य के घंटों के अनुसार भुगतान किए जाने की स्वीकृति दिनांक 17/1/2 के आदेश से की गई है। इसके उपरांत से निरंतर याचिकाकर्ता कार्य के घंटों के आधार पर मानदेय प्राप्त कर रहे हैं। Now Lordship, I am pleased to consider their case has been considered by the respondents in P13 में kindly consider page number 43. पेज नंबर 43 है सर, ट्वाइस हमने फिर कंसीडर किया द लाइट ऑफ द ऑर्डर पास बाय दिस ऑनरेबल
फाइल करिए ना, रिव्यू फाइल करिए, ये तो कुछ कंसीडर ही नहीं हुआ। यू फाइल a review that on the wrong this all has not been considered by the single bench. How it is a case of appeal? The petition is disposed of only on your reply.
उसका रिप्लाई है यदि समान प्रकृति के प्रकरण और कोई हाल ही में माननीय न्यायालय द्वारा
कहाँ, कौन सा पैरा?
इसी का पैरा रिप्लाई का पैरा पेज नंबर 57
पेज नंबर
55 सर।
May I submit one more thing?
यदि समान प्रकृति के प्रकरण और अभी हाल ही में माननीय न्यायालय द्वारा अभी याचिका
कहाँ पढ़ रहे हैं? पेज
13-14 रिप्लाई का ही जो आपने 13-5 पढ़ा, मैं
57
जो हमारा रिप्लाई है उसका पैरा नंबर
प्रकृति के प्रकरण और हाल ही में माननीय न्यायालय द्वारा रिट याचिका क्रमांक 3832/2017 दिनांक 2/3/18 को निर्धारित करते हुए ठहराया है कि चूंकि राज्य शासन के द्वारा 7/1/2016 को आदेश जारी करते हुए सभी दैनिक वेतन भोगी कर्मचारियों को नियमित कर दिया गया, तदनुसार कार्रवाई की जाए। त्वरित संदर्भ हेतु प्रकरण की प्रगति प्रस्तुत तथा याचिका की याचिका में बल न होने से निरस्त किया। इनका खुद का कहना है कि मेरा केस इससे कवर्ड होता है और उसी के लाइट मेरा केस का डिसीजन है वही 7/1/16 की सर्कुलर पे आएगी और वही जजमेंट
one more submission, Lordship. Kindly consider page number 46, Lordship. This is the third round of litigation by the respondents. We have considered the case of the respondent in the light of the order dated 5/10/2016 passed by this honorable court. Kindly consider page number 46 and 47, Lordship.
46 में तो कोई प्रधान मुख्य वन रक्षक
सर, फिर वो 43 होगा सर, 43 डबल पेजिंग सर, एक 13/12/16 का ऑर्डर है सर,
143
13/12/16 का सर। दिस द केस इन डिटेल हैज बीन कंसीडर्ड बाय द अपीलेंट इन द लाइट ऑफ द ऑर्डर पास्ड बाय दिस ऑनरेबल कोर्ट। फर्स्टली सर, जब कोर्ट ने इनके रिव्यू पिटीशन में ऑर्डर किया सर, उसके बाद भी हमने इनको कंसीडर कर लिया, वो भी मैं बताता हूँ सर। ये है इनका सर ऑपरेटिव है 1 2 3 4th पैराग्राफ सर। फर्स्ट जो पॉइंट है सर, वन रक्षक खंडवा, वन रक्षक खंडवा पेज नंबर 43।
यस
सर, ये कंसीडर किया हमने इनका केस को। वन रक्षक खंडवा सो एंड सो दिनांक 28/5/99 से प्राप्त निर्देश के पालन में दिनांक 10/6/99 में मध्य प्रदेश वानिकी परियोजना की सक्षम समिति की 6वीं बैठक दिनांक 31/5/97 द्वारा कंप्यूटर स्टाफ की संविदा नियुक्ति के संबंध में लिए गए निर्णय अनुसार श्री विनोद कुमार तिवारी सो एंड सो मध्य प्रदेश की नियुक्ति समकक्षी वेतनमान वाले रिक्त पद पर कंप्यूटर ऑपरेटर के विरुद्ध कंप्यूटर ऑपरेटर के पद पर 1 वर्ष के लिए निम्नानुसार संविदा शर्तों एवं अनुबंध के आधार की गई थी। सर, इनकी शर्तें हैं। Thereafter, Lordship, kindly consider पेज नंबर पैरा नंबर 2, शर्तों के बाद जो 7 शर्तें हैं उसके बाद पैरा नंबर 2 है, मैं रीड करूं?
यस, इस अवधि में
सर अपर प्रधान मुख्य बंदक्षक, अपर प्रधान मुख्य बंदक्षक मध्य प्रदेश भोपाल के ज्ञापन क्रमांक सो एंड सो दिनांक 27/1/2000 से प्राप्त निर्देशानुसार श्री विनोद कुमार तिवारी की सेवाएं समाप्त किए जाने हेतु इस कार्यालय का पत्र सो एंड सो दिनांक 5/2/2000 से 1 माह का सूचना पत्र जारी किया गया, जो इन्हें दिनांक 5/2/2000 को प्राप्त हुआ तथा 1 माह की अवधि पूर्ण होने से के पश्चात विनोद कुमार तिवारी की सेवाएं 5/3/2000 को इस कार्यालय के आदेश दिनांक 7/3/2000 से समाप्त की गई। देयर आफ्टर लॉर्डशिप उसके बाद है कि अपर प्रधान बंदक्षक सो एंड सो मध्य भोपाल के दिनांक 14 जून 2000 एवं वन संरक्षक खंडवा दिनांक 26 जून 2000 में दिए गए निर्देश के परिपालन में इस कार्यालय बढ़वा दिनांक 30/6/2000 से श्री विनोद कुमार तिवारी सो एंड सो की नियुक्ति समकक्षीय वेतनमान वाले रिक्त पद पर कंप्यूटर ऑपरेटर के विरुद्ध कंप्यूटर ऑपरेटर के पद पर 1 वर्ष दिनांक 1/7/2000 से
इसमें 7, 10, 16 का कहीं कंसिडरेशन ही नहीं है सर, हमको लग रहा है क्योंकि उस डेट में सर आए था 1 महीने पहले
सर ये
जो रेट पिटीशन डिस्पोज हुई थी जिसके लाइट में आपको कंसिडर करना था, उस डेट को तो सर्कुलर भी नहीं था
सर, वो
सर्कुलर 7/16 को आया, उसके बाद आपने मेरा रिजेक्ट करा।
मिस्टर शर्मा,
यस सर,
आपके रिटर्न के आधार पर किसी एक पैरा पे पिटीशन डिस्पोज आप करिए। अगर आपका पूरा रिटर्न नहीं कंसीडर किया गया तो फाइल रिव्यू दैट योर केस इज दैट ही वाज अ कॉन्ट्रैक्ट एम्प्लॉय and he was not entitled to be classified.
Lordship, my submission, I will file the review if Lordship may permit us to file the review.
Yes.
Or in alternate, Lordship, I am praying to my matter may be remanded back. So
no, not question of remand is only when we set aside the order.
We will file the review.
We don't find any illegality in the order because it has disposed.
My reply has not been considered at.
Yes.
So
लिखिए श्री शर्मा गवर्नमेंट एडवोकेट फॉर द appellant श्री हेमंत जोशी, श्री हरीश जोशी फॉर द respondent. The present inter-court appeal is filed being aggrieved by the order dated 5/12/2019 passed by learned single judge, whereby the writ petition filed by the respondent has been disposed of with the direction to the respondents to classify the petitioner as a skilled permanent employee in the pay scale of rupees 5,000-8,000 within a period of 1 month from the date of receipt of the certified copy of the order. Counsel for the appellant submits that the respondent was working on a contract basis and therefore he was not entitled to be considered for classification as per the circular dated 7/10/2016. Full stop. It is further argued that the entire reply filed on behalf of the appellant has not been taken into consideration by the learned single judge, whereby a clear stand was taken that the respondent employee was engaged as a contract employee and not on daily basis. Full stop. However, upon perusal of the order passed by the learned single judge, it is revealed that the petition has been disposed of in view of the reply filed by the respondents. Full stop. Counsel for the appellant prays for withdrawal of the present appeal with liberty to file a review against the said order. The appeal is dismissed as withdrawn with the aforesaid liberty. Yes, Mr. Sharma.
Kindly consider the order sheet of last date of hearing, wherein our Where application for the continuation of delay for the 304 days has been allowed, kindly consider order dated 14/10/2022, Lord.
Yes. Delay has been condoned.
Yes, delay has been condoned, and state has been directed to take action has been taken under the state litigation policy after fixing the responsibility of the concerned officer, and also inform the details of the officer involved and the action taken against them in filing the present appeal after the delay of 304 days, Lordship.
Yes.
So, Lordship, we have filed today, after taking the permission of this Honorable Court, we have filed the status report on behalf of appellant state, and the copy has also been supplied to the respondent, Lordship.
कॉपी दे दी हम
This is for this honorable court to consider. We are having no business with the status report, my lord. Because considering the growing tendency of the state government filing appeals after so much of time, my lord.
How much was the delay?
304 days delay. Our delay has been condoned, and in addition to condoning the delay, Lord, this honorable court has
क्या एक्शन ले लिया आपने? कब रिपोर्ट किया है?
Sir, today we have filed.
Today.
Yes.
Cost deposit 50,000.
Cost deposit कर दिया? Yes. Cost deposit कर दिया? Sri Akash Sharma, Government Advocate for the appellant, Sri L.C. Patne for the respondent, Counsel for the state submits that, Counsel for the appellant submits that in compliance to the order dated 14th October 2022, the appellant has filed a status report regarding action taken against the erring of officers today. Copy of the office is directed to place the said report on record, list the appeal for hearing on admission after 2 weeks. He comes from outside. But Wednesday we don't know, it's not regular bench. It will be listed. We are adjourning, but this is bench is not constituted on Wednesday for the writ appeal. लिखे श्री विवेक फड़के, लंडन काउंसिल फॉर द अपीलेंट. आपका नाम? MS अनुष्का भार्गव, on behalf of respondent number 1 at the request of counsel for the respondent, case is adjourned for 2 weeks. Yes.
Lords, in pursuance of the directions of the Honorable Court, Lords, a strange affidavit has been filed by the state government, Lords. I just draw your Lordship's kind attention to that affidavit which has been filed, Lords, and the Google map which is to be proposed road, Lord, to the industrial area. Now, Lord, I'll just straight away come to the affidavit of the state government which has been filed on 26/9. I'm open to correction on the question of date, Lord.
Yes.
My submission is they don't, because last proceeding says, my Lord, which Lordship is pleased to consider, that we are filing the status report and additional affidavit.
to file fresh affidavit along with the status report.
अब आपने फाइल करा उसी की बात कर रहा हूँ
लास्ट डेट पे और आखिरी लाइन में लिखा है कि if they want to file any response to so they may file. If they don't want to file any response and directly want to argue on our affidavit, the position is different. So let it be clarified. If they want any written response or not.
Yes.
That would be better.
All these appeals are arising out of one order,
Yes, yes.
same order. No, because we don't know the background, etc.
Not that is not more or less facts are
What is-
undisputed. We will not take note as far the background
It is
concerned,
found
we will
that
not take
there
note.
appears to be a major deviation from the earlier plan of the road as has been mentioned by the respondent.
That is not the crux is the issue about which your lordship is pleased to read right now.
The length
The
of the road.
MPSI DC says it's a 900-meter straight road which leads to our factory, providing us an access to the factory. The state government, employed contrary to the plans of the MPSI DC, now comes up with a proposal that now we intend to acquire the land from the landowners for which an acquisition amount is sought to be got from one arm of the government, which will take its own amount of sweet time, and then after that also we will make 50% of the road and leave the 50% to be made by you from your own pocket.
When did you file your affidavit and status report?
Sir, last date to 26 9. 26 9 की proceedings lordship में फाइल 26 9.
You want to file any response or not?
It's not a week's time. We will file a respondent to it.
They will take 3 weeks time.
नहीं आप हम कितना समय लेंगे ये तो आप हमको तय करने दो
मैं सेवा साइड में बता रहा हूँ.
नहीं हम सेफ नहीं हम हफ्ते भर में भी सेफ नहीं है, कोई दिक्कत नहीं हमारी सेफ
ये 2 महीने में नहीं कर पाया वो ठीक है हफ्ते भर
नहीं समय सरकारी ज्यादा लेती है प्राइवेट रिटेलर तो वैसे समय से नहीं कर देता
So far as considering the controversy in question, my lord, all writ petitions are dismissed.
therefore there is a writ appeal obviously.
Yes. What I
if our petition would have been allowed we would have come a writ appeal.
Just let him complete.
The railway department wants to double the road, double the lines.
Yes.
Earlier there was a single line.
Okay, which is that line?
Devas के पास से जा रही है.
From
1.65 kilometers length is affecting, according to the petitioners, their way of
factory.
The learned report has categorically recorded the finding that they are having the alternative road, and there is a unki land heavily. In spite of on that basis, the writ petition was disposed. There was no reply on behalf of the state government in the writ petition. They have filed the writ petition, writ appeal. In writ appeal, in paragraph number one paragraph, now they are coming with the case that industrial policy provides that they are duty bound to provide the infrastructure in terms of road to the industry. And on that basis, on 15/3/2022, this honorable court has widened the scope of the writ appeal.
Yes. 15/3/2022.
Yes.
Yes.
यानी इंडस्ट्रियल पॉलिसी की प्लीडिंग इनकी ओरिजिनल पिटीशन में नहीं है.
Yes, MPRDC was.
Yes, madam. Considering the situation, madam.
Yes.
Earlier we have filed the reply in the petition.
Yes.
Thereafter one affidavit of collector they passed.
Yes.
Now they are now the situation is under the industrial policy we are willing to construct the road. Now what they want that हमारी तरफ से तो पहले रोड बना दो आप इंडस्ट्रियल एरिया का कुछ भी नहीं. Now when state is considering the situation, it is required to consider the situation so that overall situation can be looked into. तो अब वो हमारे एफिडेविट को पहले काउंटर दिया इन्होंने और ये कहा कि हम हमारे पहले स्टैंड से डेविएट हो रहे हैं. It is not the case that we are not willing to construct the road. और उस कंस्ट्रक्शन में we are required to acquire the land of 3 private persons. That proceedings are going on, my lord. We are trying that on the basis of negotiation we should get it.
It should be settled. So, ठीक है, let them file the response, then we will.
My lord, the submission is.
Yes, Mr. Jain.
My lord, the earlier bench has examined all these things, my lord. My lord, they are bound to provide access to the industries, my lord, which has been closed because of widening of railway line, my lord.
Yes.
And my lord, we have submitted before the earlier bench, my lord, that a straight road of 900 meters only can be safely constructed, which will provide access to all industries and one big residential colony also.
Yes.
तो उसके अगेंस्ट एक ये नक्शा बना के लाए 3 किलोमीटर लंबा रोड जिग जैग जो कोर्ट ने ऑब्जर्व किया अपने ऑर्डर में. तो फिर इनसे कहा कि भाई आप दूसरा एफिडेविट फाइल करिए. तो ये दूसरा एफिडेविट लेके आ गए और इन्होंने कहा कि अब हम या पीछे से इतना रोड बना देंगे, इसके आगे का आप बना लेना. और जो सीधा रोड है 900 मीटर्स का, जिसकी कॉस्ट ऑफ कंस्ट्रक्शन जो ये नया रोड बनाएंगे आधा, उससे आधी आएगी, 1/3 आएगी बल्कि, और उसमें कोई लैंड एक्विजिशन का भी जरूरत नहीं है. तो उसके लिए सारा एक्सप्लेनेशन से मांगा था, तो एक नया एफिडेविट फाइल कर दिया कि बोले अब हम ये कर. एंड द होल आइडिया इज नॉट टू कंप्लाई विद द कोर्ट ऑर्डर, not to secure the employment which these industries are providing. And what your industrial policy says, that you are promoting industries and investment to come in the state of Madhya Pradesh.
Yes.
And this is nothing but sheer एक वो बना रखा है कि आपकी बात नहीं मानेंगे, भले उसमें गवर्नमेंट का फायदा हो रहा हो तो भी आपकी बात नहीं मानेंगे.
Yes. We will hear.
Yes.
On the next day. देखिए ये WA1133 में कौन है? मिस्टर श्रीवास्तव.
On behalf of Mrs. Srivastava.
What's your good name?
Anushka Jain.
Anushka Jain. MS Anushka Jain, learned counsel for the appellant in WA1133 of 2021. Sri Ajay Bagadia, learned senior counsel with Sri Gajen Singh Chauhan for the appellant in WA1089 of 2021. Sri VK Jain, senior counsel with Sri
Pratik
Patwardhan, learned counsel for the appellant in WA1110 of 2021. Sri Umesh Gajan Khush, learned additional advocate general for the respondent state. Sri Kushal Goyal for the respondent number 3. For number 4, Mr. Mehta. Sri Rohan Sundecha for the respondent number 4. Number 5 के लिए none for the respondent number 5. Yes, Sri Nimgaonkar, Sri Abhinav Ganotkar for the respondent number 6. लिखिए. Counsel for the estate submits that he has already filed additional affidavit along with the status report on 26/9/2022. Counsel for the appellant. Only Mr. Bagadia, you want to file response?
No, both of us.
Counsel for the appellants prays for time to file response to the said report. Place the matter after 2 weeks. Yes. Yes, Mr. Nayak.
Please, Manoj. Manoj, one application came to be filed by respondent Indore Development Authority for tagging this matter along with other so-called identical matters.
Yes.
This is my lord, IA number 7268 of 22. In this application, my lords, our contention is that this matter is not identical to that, although the impugned order is same, my lord. There is no dispute about that the impugned order is not the same, but the reliefs claimed are altogether different. My lord,
Impugned
those writ
order
appeals
by the single judge.
Yes, my lord.
He disposed of the other petitions also by this order.
Same orders, my lord. Land acquisition, my lord, the only difference is they are
No,
claiming
we will decide them separately.
Yes.
But let the matters be listed along with the.
My lord, those are bunches pertaining or seeking the same reliefs, my lord. But this is the only petition which is claiming different relief. Though my lord, the acquisition is same and even the impugned order is same, but the nature of relief is altogether different. That is having no.
But the order passed by the single bench is common order.
But the parameters of adjudging the relief sought by the present appellants.
Mr. Nayak, we will hear your appeal separately. What only that the matter may be listed along with those.
So, my lord, my submission is only I am praying for that if it is not tagged, I will be more comfortable in arguing because my lord, rest of the appeals are to be argued on the
arising out of the same order.
But rest all matters are to be
Propriety
argued.
requires that they should be heard simultaneously. We will
Because the reliefs are different. That is my humble submission, my lord. And point.
In the writ petition, they had earlier claimed the relief on the basis of the section 24(2). Later on, they amended it and they claimed relief by virtue of the proviso appended to section 24(2).
So we have confined our relief, my lord.
They have confined it.
And that relief is not sought by rest other petitioners, my lord.
Yes.
So therefore, my lord, the parameters of adjudging whatsoever is the argument, my lord, that is altogether different because the other appeals are to be adjudged for 24(2).
What is the order passed by learned single judge?
My lord, it is the claim of lapsing of acquisition under section 24(2) of Land Acquisition Act. And my lord, initially we also landed with the same relief, my lord, before the Honorable Red Court.
What happened to the those appeals?
They are pending adjudication before my lords.
They were.
Listed, but due to the non-availability of the bench here options and
That is assigned bench, my lord.
Anil Verma's bench was
Those matters are to be listed before the assigned bench.
Yes.
This matter is not to be listed before the assigned bench. This is allotted to DB2, and therefore it is before my lords.
Likhe.
One more submission. Because in the writ appeal, their primary ground is that they filed an application for amendment that was allowed, wherein they claimed the relief by virtue of the proviso to section 24(2). Now they say that there is no reply to it. Well, the issue with it has certain factual issues which is to be also decided. They say that as majority of the claimants did not get compensation, so by virtue of the proviso, we should be given compensation as per the 2013. Now this issue or this amendment, though it was allowed, but that was not answered by the state government. Well, if a response is also taken from the state government, so that will clarify the entire issue and also it will facilitate.
No amendment in the writ appeal.
Writ petition. We already did it, my lord. We already did it, and
it is for the state
government to clarify this issue by way of an affidavit. So that
because my lord, in those writ appeals, my lord, still they are insisting for lapsing. If not lapsing, then they are, my lord, coming down to that unutilized land may be released.
Yes.
These are the relief sought in other writ appeals. Whereas in our appeal, my lord, we are only seeking a recalculation of compensation under the new act on account of proviso.
Likhe. Sri Aniket Nayak for the appellants. Sri Akash Sharma, government advocate for the respondents 1 to 3. MS Mini Ravindran, learned counsel for the respondent number 4. IA 7268 of 2022 filed by the respondent number 4 is taken up. Full stop. It is stated that the present appeal and the other appeals. The present appeal is arising out of an order passed by the learned single judge common order of the learned single judge, whereby various writ petitions have been decided. Full stop. The other writ appeals arising out of the same order have been filed, and the present writ appeal may also be taken up along with the aforesaid writ appeals. Full stop. Counsel for the appellant submits that though his writ petition was also decided by the said same common order, but the relief claimed in the present writ appeal his petition and in the present appeal is different. However, considering the fact that all the appeals are arising out of common order passed by learned single judge, we deem it proper to link the present writ appeal along with the writ appeals. ये आइए में जो mention है, ये flag लगा है, इनके साथ लिंक कर दीजिएगा. WA 640 of 2022, WA 540 of 2022, WA 522 of 2022, WA 375 of 2022, WA 1095 of 2022, and
that is disposed of.
RP disposed of.
RP is disposed of.
बस इतना ही रखिए.
Malad, if required, it may be heard separately in the bunch.
Yes, Malad, even we will,
आपका इसीलिए वो लिखा दिया है.
Because that is the sole crux of our preferring the appeal, my lord. Else we would be in the same bunch and getting an adjudication order of 24/2.
I also concede to this fact that it will be
heard separately.
argued separately.
Yes.
Malad, only submission is that a date may be given because Malad, today the bunch was to be listed. It's because of the non-availability.
We don't know that.
So a date may be given because in the Supreme Court,
The difficulty is that this bench is not a regular bench.
Yes.
We don't know where this matter will go.
Malad,
That's why we are not giving a fixed date.
Now it is taxed, so it will come before your lordship only because other matters are assigned to your lordship's bench.
The bench itself is not decided when it will be constituted.
So a week may
There is no regular roster for this bench.
Malad, or else we'll have to again mention these matters. But
Yes.
due to the fact that the Supreme Court has already
We will
fixed the
decide.
case for today, Malad.
This is a special bench. This is the difficulty, and no day is fixed. That's why we are not fixing a date. Yes.
My lord, this matter was heard at length, my lord, by the division bench consisting of Honorable Justice Subodh Abhinkar. And my lord may kindly peruse the order.
Which
dated-
29?
Yes, sir.
Order sheet is
On 29th of July, my lord, this matter was heard at length, my lord. And thereafter, on 27th of October, Honorable Court directed us to, my lord, submit a specific point, my lord, submit arguments on specific point. 29th of July, there is a common order passed by this Honorable Court on 29th of July and on 27th of October, my lord. 29th of July, the matter was heard, and thereafter, my lord, on 27th of October, an order was passed by this Honorable Court, wherein a specific query has been raised, my lord. So my submission
When
is,
it was heard,
my lord, 29th of July, this matter was heard. Thereafter, on 27th of October, Honorable Court. So we'll save a judicial time, my lord, in case if this matter be listed before the same bench on any Friday.
yeah, Mr. Sarma, you also submit that it was heard at length. Order sheet में तो ऐसा it is not reflected.
On 29th.
But अगर both of you say
My lord.
that it was heard, then we can.
There is an order of 27th of October, my lord. If my lord may peruse the same, my lord.
On 27th of October, there is an order wherein two dates has been specified, matter 29th of July and 27th of October. Both the dates have been mentioned, and it is specified that counsel for the respondent is directed to apprise the court as to why rule so and so would not be applicable in the present case. So this is the specific query after the arguments were heard and the matter was kept reserved, my lord. Thereafter, this specific query has been raised, my lord. So
it was heard on 29th July.
29th of July.
Then on 27th this order was passed.
Yes, your
Lord.
And Akash Sharma sahab is appearing in that case, my lord, on the same day, my lord. So he is also aware of the fact that the matter was heard at length. It is approximately 2-3 hours hearing, my lord, which has been taken place.
Sri Arpit Kumar Oswal, that is counsel for the appellant, Sri Akash Sharma, government advocate for the respondent state. Parties submit that the matter was heard at length by division bench comprising of Honorable Justice Subodh Abhyankar and Honorable Justice Satyendra Kumar Singh, and thereafter a query was made to the counsel for the state, full stop. At the joint request of the parties, office is directed to list the matter before the same bench.
On any side, because
that we can't fix, because that bench is also to be yes.
This is a retired government servant seeking pro forma promotion from date when his juniors are promoted. The petition dismissed only on ground of limitation. Review also filed same is dismissed.
Yes, seeking implementation and entry.
18/5/2005 ऑर्डर ना 18/5/2005 ऑर्डर P1 रीड पिटिशन
नहीं my brother queries 18/5/2015 passed in the writ petition.
15 गलत लिखा दिया 5 है 5 का ही पूछा हूँ
5 का है
P1 है मिनट पेज 13 ये 18/22 का है P1 तो W8 का पेज 9 पे रीड पिटिशन में मिला पेज 18/5 का ऑर्डर रीड पिटिशन में है P1 पेज 13
कुछ नहीं है भाई क्या इतना डिले कुछ नहीं रिव्यू भी खारिज हो गया आपका
रिव्यू में मेरा कंसीडर नहीं किया इसमें रिव्यू में मेरा उन्होंने नया पॉइंट रेज किया कि सेकंड रीड पिटिशन इज नॉट मेंटेनेबल फॉर इम्प्लीमेंटेशन ऑफ अर्लियर ऑर्डर मतलब दैट इज मेंटेनेबल मेरा एपेक्स कोर्ट का ऑर्डर है उसमें
क्या ऑर्डर है
जजमेंट है एपेक्स कोर्ट उसमें ये कंसीडर किया सेकंड पिटिशन इज मेंटेनेबल फॉर इम्प्लीमेंटेशन
फॉर एग्जीक्यूशन ऑफ द ऑर्डर
implementation of earlier order.
हाँ which is बताइए
तेरा ट्रेनिंग क्या ऑब्जेक्शन दिया तेरा ट्रेनिंग
ये तो उनका कंटेंशन है कोर्ट का
ऑर्डर जो है वो पेज 23 पर है पेरा 23 है
23 ऐसा कुछ होल्ड तो किया नहीं उन्होंने
लिमिटेशन के पॉइंट पे मिनट कंटिन्यू राउंड पे डीसीए ने मिनट अनलेबल एपेक्स कोर्ट का वो रिव्यू पिटिशन के साथ फाइल किया है सरसेम सिंह वाले जजमेंट में उसमें यदि ये है कि कंटिन्यू राउंड है
कंटिन्यू
राउंड गलत हो रहा है किसी के साथ में तो वो सुधारा जा सकता है हमारे साथ मिनट 93 में हमारे से जूनियर को प्रमोशन दे दिया
अब तो फिर लॉ ऑफ लिमिटेशन डिले लैचेज सब रिडंडेंट है अगर रॉन्ग कंटिन्यू है
जी मिनट इसमें जो है हमारे वजह से डिले नहीं हुआ है हमारा एलोकेशन छत्तीसगढ़ स्टेट में कर दिया था मैंने और वो पिटिशन भी फाइल की थी उसमें ये ऑर्डर हुआ मिनट कि
अभी एलोकेशन आपका कहाँ का है
अभी तो मैं रिटायर्ड हो गया मिनट एलोकेशन भी एमपी में वापस हमारा कर दिया है
31/7/21 को रिटायर ही हो गया
तो एलोकेशन मिला ये 21 में ही किया है P8 के द्वारा एलोकेशन ऑर्डर जो है वो मध्य प्रदेश में वापस किया है।
वो कहाँ है?
वो P8 ये P6 से है मिला रीट पिटिशन में पेज 41 पर वही 21 में
पेज 40 नहीं लगी हुई
41 मिला
पेज 41 आपको मध्य प्रदेश कर दिया?
मध्य प्रदेश का दिया मेरा पेरा 1 नहीं है। ये नंबर 1 पे नरेंद्र कुमार गुप्ता से है केंद्रीय ये 15 आवंटित राज्य है। तो ये मिनट 2000 से लेके 2021 तक ये सीनियरिटी हमारी फिक्स नहीं हो रही थी और ये सीनियरिटी
कितना फर्क पड़ेगा? आप असिस्टेंट इंजीनियर तो बन गए
7-8 हज़ार रुपये का सैलरी में
पेंशन पे
ओनली प्रोफार्मा प्रमोशन मिला 84 के भी एक कर्मचारी का प्रमोशन रुक गया था वो उसको प्रोफार्मा प्रमोशन अभी दिया मिला 1/10/2021 को वो ऑर्डर भी मैंने इसमें लगाया गवर्नमेंट का ऑर्डर है।
हाँ ये बताइए ये डीपीसी कब की थी है? 92 की डीपीसी
2005 में मेरे फर्म में जजमेंट हुआ मिला रिव्यू डीपीसी के लिए।
किसको दिया लगाया पेज हाँ ये 1/10/2021 ये आपने पेज 1 क्या लगाया है? ऑर्डर 110/2021
मिला इसमें ये 84 में प्रमोशन से ये रुक गए थे तो इनको अभी 110/2001 में प्रोफार्मा प्रमोशन दिया मिला 84 से प्रमोट लास्ट लाइन में सेवानिवृत्त उपयंत्री को सहायक यंत्री सिविल के पद पर 29/12/2084 से प्रोफार्मा पदोन्नति प्रदान की जाती है। ये अभी 2021 में मिला प्रोफार्मा। आई एम सीकिंग ओनली प्रोफार्मा प्रमोशन अभी तो 2000 में मुझे प्रमोशन मिल गया फ्रॉम 1990 और मेरे फेवर में जजमेंट मिला वो डिले इनके कारण हुआ मिला काइंडली सी पेज 10 ऑफ रिव्यू पिटीशन मिला।
ठीक है वी विल कंटिन्यू आफ्टर ब्रेक। देखो गिर जाएंगे। Yes. Mr. Mitha, so far the merit is concerned, we don't find any error with the order passed by the single bench for interference in the writ appeal. It is better you approach the respondents, for we will give you liberty to approach the respondents by filing a representation, because in one order they have given on the basis of no work, no pay, etc. in cases of some engineers. You file better, you file. I think that is the best. Otherwise, so far the order is concerned, there is nothing wrong with the order. लिखिए Shri Pramod Mitha for the Pramod Kumar Mitha for the appellant Shri Sarma, government advocate for the respondent state, counsel for the appellant praised for withdrawal of the writ appeal with liberty to approach the respondents for redressal of his grievances for promotion on the post of assistant engineer by constituting a review DPC. आप अप्रोच करिए उनको.
इसमें टाइम लिमिट फिक्स उसके लिए वो डिसाइड करें विद इन मंथ, विद इन 2 months, अदरवाइज दे विल नॉट डिसाइड.
लिखिए वहीं जहाँ लिखा लिबर्टी के बाद, if the appellant files a representation within period of 15 days from today before the competent authority, the same shall be considered and decided by the said authority in accordance with the law within period of 2 months from the date of receiving of the representation. Yes, the appeal is dismissed.
I will be eligible for legal.
Oh, वो तो fresh cause of action होगा ना आपको.
इसमें आ जाएगा.
नहीं, we are not saying, otherwise that would amount to setting aside the order passed by single judge. That can't be. On merit there is nothing, no case. Yes.
In this case, my lord, senior counsel argue SM Bangar, my lord, is come from Susner, my lord. और वहाँ पर रोड बंद होने की वजह से वो आज उपलब्ध नहीं हो पाए. my lord, इसमें लास्ट ऑर्डर देखेंगे 4/11 का, जिसमें लोक निर्माण विभाग को पार्टी बनाए जाने के लिए निर्देशित किया था, और दूसरा इसमें रिप्लाई और रिप्लाई फाइल करने का भी कहा था my lord. और इसके साथ में कंप्लाइंस का भी था कि इसके साथ अदर 2 और 3 WP और
तो आपने बना दिया, पार्टी बना दी?
my lord बना दिया है, बट इसके साथ जो WP अलॉन्ग विथ लगना थी वो भी लगी नहीं है आज. 24,734, 24,738 my lord. आप देखेंगे लास्ट ऑर्डर की प्रोसीडिंग देखेंगे my lord. उसमें लास्ट ऑर्डर ये था कि रिप्लाई भी फाइल करें और दूसरा ये प्राइवेट पार्टी बनाए और दूसरा इसके साथ अलॉन्ग विथ रखे, क्योंकि 5 और 6 मैटर एक साथ एक ही उससे रिलेटेड.
वो आज नहीं लगे?
नहीं लगे मतलब लास्ट प्रोसीडिंग में भी है, ऑर्डर में भी लिया है.
आपका रिप्लाई आ गया है क्या?
नो my lord, they didn't file any single reply.
My lord, we have not filed the reply. The reply has to be finalized by NHA. We have sent to the client, my lord.
My lord, in this case, my lord, I need, I got information that कि आपके द्वारा वहाँ ओरली बोला जा रहा है कि हम ये कार्रवाई करेंगे. 2 से 3 किलोमीटर सोयत जो है, जहाँ पर जो एक बस स्टैंड का जो मामला है, जो विवादित स्थल है, वहाँ पर ये ओरली ही बोलकर उनको नोटिस दे रहे हैं, वहाँ जो लोकल रहते हैं।
क्या नोटिस दे रहे हैं?
कि हम इनको तोड़ देंगे, आप इतनी इतनी जगह कम वो कर लें। दूसरा इसमें जो विवादित स्थल का जो पूरा मामला है मालूम, मेरा एक रिप्लाई ये फाइल कर दे, मीनवाइल नो एक्शन में भी टेकन।
अरे नहीं, ऐसा कौन, विदाउट देयर बीइंग एनी मटेरियल। देखिए, श्री लीलेश बनोरे for the petitioner, Sri Sharma, government advocate for the respondents. Number 4.
My lord, sir, not Sharma, Ankur Sahu for NHA.
For respondent number 6, Sri Ankur Sahu.
Ankur Sahu. My lords, for respondent
Sahu.
number 1 to 3.
1 to 3 के लिए
1 to 3 for 1 to 3 and for 4.
Yes.
You are for 4.
You are for 4 and 6.
6 is लोक निर्माण।
4 and 6 के लिए शर्मा जी का कर दीजिए, और श्री अंकुर साबू।
Ankur Sahu for respondent number 1 to 3.
1 to 3. साबू या साहू?
Sabu, B for Bangalore.
Bangalore. Sabu for the respondents 1 to 3. Counsel for the respondent prays for and is granted. How much time?
My lord, sir, 2 weeks.
2 weeks time to file reply. List the matter along with WP 24734 of 2022 and WP 24738 of 2022.
One more.
As per court order in terms of the order dated 4/11/2022.
One more WP is also there.
WP
22824.
WP एक और जोड़ दीजिएगा,
22824.
824
of 2022.
मालूम।
My lords, there is only one request, my lords. The reply can be filed within a period of 4 weeks. Because my lords, my marriage is due on 11th of December, my lords.
My lord, but वो आपके सीनियर को अपेयर होना, my lord,
नहीं,
आपसे।
सीनियर नहीं, मैं ही आर्ग्यूइंग काउंसिल हूँ। मेरी शादी है इस मंथ, तो मैं खुद ही आर्ग्यूइंग
तो भाई
काउंसिल।
बड़ा जेन्युइन रीजन है।
my lord 3 week कर दें।
3 weeks कर दीजिए।
शादी का टाइम दोगे आप?
भाई मनोहर साहब को इनवाइट करिएगा और शर्मा साहब को भी।
उसमें मीनवाइल कोई भी एक्शन नहीं ले, my lord। इसमें
अरे
यदि ये बीच में मिलेंगे तो फिर मेंशन लेना
अभी
पड़ेगा।
कुछ नहीं, अगर नोटिस वगैरह
लास्ट
देते
टाइम आपने ही कहा था कि वहाँ हम कोई तोड़फोड़ नहीं कर रहे, बट वहाँ की जो लोकल जो पोजीशन है, my lord।
आने दीजिए, कुछ मटेरियल तो हो पहले।
मिलट आई एम नॉट, मैं संतुष्ट नहीं हूँ इस आदेश से। मिलट मैं मेरिट पे ऑर्डर चाहता हूँ,
मेरिट पे
एडजन कर दे मिलट।
आज नहीं बहस करना चाहते, आपने तो कर ली।
नेक्स्ट टाइम
30 को फिर बढ़ा दीजिएगा, अभी लिखाया था ना विड्रावल वाला, लिख दीजिए श्री प्रमोद कुमार मीठा फॉर द appellant, श्री शर्मा फॉर द गवर्नमेंट at the request of counsel for the appellant, case is adjourned. 32, 33 same. Yes.
34. Last date of hearing, I was directed to take instructions, my lord. As per the instructions, my lord, my instructions are to file a detailed reply in this petition.
Yes.
Petitions are for attachment of several FIRs which are registered by the respondent, my lord. So, my lord, the report of all these cases are running into 1 lakh pages. So, I will kindly granted 8 weeks time to file the reply.
My lord, on the last date of hearing, that is 24th of November 2022, this honorable court was pleased to consider that they are going to file identical charge sheet, each comprising of 2000 pages, and in 47 cases, my lord. So the number of pages which they are going to consume for filing identical charge sheet is around 6 lakh pages, my lord. And the crux is same, only the name of beneficiaries are different. And they have implicated the present petitioners, all of them, into all the 47 cases. And now they have started filing charge sheet. So out of 47, they have filed charge sheet in 7 cases before.
14 cases.
7 cases before filing of the petition, and after filing of the petition, before listing of the petition, they filed in 7 more cases. So on the last date, that is 24/11, immediately a next week date was granted so that they can give a proposal that they can file a common charge sheet for all the cases. Otherwise, my lord, it would be difficult for the trial court also to conduct 47 trials, for me also to obtain 47 bails, whereas the subject matter and the cause of action is identical.
Who are you?
I am the accused persons in all the 47 FIRs. I am the Sarpanch of Gram Panchayat, Up-Sarpanch of Gram Panchayat, and Secretary of Gram Panchayat.
So let it be decided by
In main judgment on this point. fine.
Yes.
If beneficiaries are different, then different FIRs has to be filed.
It is for them to decide that whether how the writ court can direct that no, you file a common charge sheet, etc.
Article 226, if you lordship permit, I can point out the Supreme Court
We will
judgments
here
also.
let them file the reply.
So, my lord, my only submission is that in the meanwhile, before filing of the reply, they should not file any other charge sheet. They have already filed in 14 cases, because otherwise the purpose of filing this petition would be, my lord,
How
infructuous.
that would prejudice you?
My lord, as
How
soon
that
as they
would
give me a
prejudice
notice,
you?
I'll demonstrate, my lord. As soon as they'll give me a notice that we are going to file charge sheet on such and such date, you appear before the ADJ.
So I appear before the ADJ, I move a 439 application before the ADJ, and then if ADJ dismisses that application, I need to run to this court and file a fresh 439 application here. So I have already obtained bail in 14 matters. Now in remaining 35 matters, if I have been forced to obtain bail, my lord, then there would be a great prejudice to me, my lord.
That is the law. You have to obtain bail in each case.
So my humble submission is that the cause of action is identical. The cause of
this.
In fact, the honorable single bench in bail matters have passed a order in such a way that in all other matters they are getting bail. Now that is not an issue. Bail is not an issue.
लिखे श्री पौरुष राका for the petitioner, Sri Vaibhav Jain for the respondent, counsel for the respondent. Please for and is granted 4 weeks time to file reply.
My lord,
अरे तो फाइल फिर टाइम ले लीजिएगा अगर नहीं अभी से 8 weeks कैसे
a fixed date may kindly be given, my lord. So the
Yes.
a fixed date may kindly be given, my lord.
अरे what is the urgency?
Much obliged.
Yes. Yes, Mr. Jain.
May I please, Your Lordship, my lord, by filing this petition, the petitioners will challenge various provisions of the Waqf Act, holding them as unconstitutional, my lord, on the ground of unreasonableness running contrary to the provision of Constitution of India, my lord. On last date of hearing, this honorable court was pleased to direct us
to furnish the details whether these provisions have been challenged before any other High Court or Supreme Court, my lord. But I have tried to collect the details, my lord.
Yes.
And to this effect, I have filed an affidavit giving all the details, my lord.
Yes.
But the first of all, one Ashwin Kumar Upadhyay had filed a writ petition before the Honorable Supreme Court, which was registered as WPS Civil number 1080 of 2021.
Yes.
Which was dismissed as withdrawn with liberty to avail the other remedies which may be available. Thereafter, he filed a writ petition before Honorable Delhi High Court,
Yes.
wherein the Delhi High Court was pleased to issue notices, my lord.
Yes.
One petition is also pending in the state before Allahabad High Court, my lord, that is WP 6332 of 2022,
Yes.
wherein also notices have been issued.
Yes.
And the third petition,
So decide अभी तक नहीं हुआ.
डिसाइड अभी भी नहीं हुआ, मतलब जहाँ तक मैं एफिडेविट मेरे क्लाइंट ने फाइल किया है.
Yes.
So this is also petition, my lord, challenging the various provisions of the Waqf Act, my lord.
Very well. We will.
My lord, your lordship may just kindly have a look at the order passed by the Honorable Delhi High Court.
No,
which is
we are not deciding on merit. We are.
No, my lord. It is only this order only reflects, my lord, that the Delhi High Court has issued notices in this type of petition.
We are also issuing notices. Sri Sunil Jain, Senior Counsel, with Sri Manish Gupta for the petitioner. State party है.
हाँ, स्टेट भी है और यूनियन ऑफ इंडिया भी है.
Sri Umesh Gajan Khus, Additional Advocate General for the respondents E and F. लिखे in terms of the court order dated 23rd 11 2022, an affidavit has been filed stating that the validity of the provisions of Waqf Act have not been finally examined by any court of law.
Precisely, this has not been stated in the affidavit, my lord. We have only said that these matters are pending before, and to the best of knowledge of
Finally, I have used word finally.
Yes, my lord.
Finally not adjudicated. In some high courts have issued notices and the matters and the petitions are pending. Considering the aforesaid submissions, admit कर लेते हैं इसको तो petition is admitted for final hearing. Issue notices to the respondents on payment of PF within 7 working days by both modes, returnable within 6 weeks.
एडमिशन में थोड़ा फिर वो हियरिंग के लिए रिव्यू कोर्स चला जाएगा.
ये मैटर तो hearing it requires
hearing, sir.
We will fix for hearing after reply, etc.
I am okay.
Yes. Item number? Yes.
May it please your lordship.
Yes.
This petition is preferred, your lordship, against the annexure P1 and P2, by which I am the only bidder and my tender was turned down by the respondents, your lordship, for the reason that my bid was higher to the amount which was made available by the government, your lordship. The note sheet is annexure P1, page number 12, your lordship.
Your tender is rejected?
Yes, I am the sole bidder, your lordship, in that tender. It was for the providing the catering services to the government girls hostel, your lordship. May I read the relevant paragraph? That is.
Where is the impugned decision?
Page number 12, annexure P1, your lordship.
Yes, annexure
P1.
P1?
Yes, your lordship.
Yes.
This is the note sheet. Though the note sheet was not at any point of time it was communicated to me, but it was uploaded to the net. The last paragraph may I read? समिति द्वारा संबंधित फर्म ऑब्लिक ठेकेदारों के दस्तावेजों का अवलोकन किया गया, जिसमें संविदा की शर्तों के अनुरूप चाहे गए दस्तावेज सही पाए गए. साथ ही फर्म द्वारा ₹100 जीएसटी सहित प्रति छात्रा के हिसाब से निविदा दर प्रस्तुत की गई, जो कि शासन द्वारा प्रतिमाह उपलब्ध कराई जाने वाली राशि से अधिक होने से समिति द्वारा सर्वानुमति से पुनः निविदा बुलाए जाने का निर्णय लिया गया. आई एम द सोल बिडर, या ऊपर इसमें लिखा हुआ है निविदा अंतर्गत एक टेंडर फॉर्म निम्न फर्म द्वारा क्रय किया गया, दैट इज द पिटिशनर फॉर्म. एंड द सोल रीजन फॉर कॉलिंग अ न्यू टेंडर was mentioned कि जो मैंने जो अमाउंट जो मैंने टेंडर किया है, that is the higher to the amount which is made available by the government. by the government ये लिखा है सर कि शासन द्वारा प्रतिमाह उपलब्ध कराई जाने वाली राशि से अधिक होने से समिति द्वारा सर्वानुमति से पुनः निविदा बुलाए जाने का निर्णय लिया. That amount was not disclosed in the advertisement, your lordship. The entire NIT firm, they did not disclose the highest cap of the amount, and now this is one kind of the thing that they are dismissing my bid by including a new condition that is not permissible.
फर्म द्वारा 1,24,095
नहीं, 124 रुपए
124 रुपए 95.
हाँ, 95 पैसा
जीएसटी सहित प्रति छात्रा के हिसाब से, जो कि शासन द्वारा, तो वो आपका कैसे निविदा स्वीकार करेंगे?
सर ये इसलिए स्वीकार,
आपको प्रति स्टूडेंट जो है
जी सर
वो 124 रुपए 95 पैसा चाहिए
जी, मुझे 124.
और गवर्नमेंट उसे कम दे रही है.
तो ये इन्होंने टेंडर में कभी डिस्क्लोज ही नहीं किया. हाउ मच दे आर डिस्क्लोजिंग. इन्होंने कोई अपर कैपिटल सर, जब तक ये उसमें डिस्क्लोज नहीं करेंगे कि ये इससे ऊपर के टेंडर नहीं होंगे.
टेंडर एनआईटी कहाँ है
सर? एनआईटी इज annexure P3, पेज नंबर 15 onwards. 15 onwards, sir. इसमें जो फूड अवेलेबल कराना है, that is on page number 61. and जो conditions हैं, जो important conditions हैं, that is on page number 29.
Page number
29. इसमें 2.9.2 stage 2 commercial bids. इसकी अगर आप second paragraph पढ़ें, the bidder that has quoted the lowest total price L1 shall be awarded the contract. इसकी फिर एक और, the bidder should take care of the rate mentioned specifically covers the express that the bidder shall incur on the project of the mentioned in the scope of work. There should not be any separate cost for each item. Sir, I am relying on the apex court judgment.
On what point?
Sir, the first, whatever procedure the government process to follow the accepting the tender must be clearly stated in the tender notice. The consideration of tender received and the procedure to be followed in the matter of acceptance of a tender should be transparent, fair and open. They have never disclosed what is the cap of the highest cap of the amount. And now they are rejecting by stating something which is not in the NIT. They must have to mention this कि आपका जो भी टेंडर है वो इस पर्टिकुलर अमाउंट से, ये अमाउंट हमको गवर्नमेंट ने सैंक्शन है, इससे ज़्यादा नहीं होना चाहिए.
फ्रेश NIT इशू कर दिया.
फ्रेश NIT इशू कर दी सर.
फ्रेश NIT में लिखा है क्या?
नहीं, फ्रेश NIT में भी नहीं लिखा है. अगेन दे आर डूइंग द सेम थिंग सर. फिर ये गवर्नमेंट एक्सचेकर के ऊपर एक अनदर फाइनेंशियल बर्डन है सर. गवर्नमेंट एक्सचेकर के ऊपर फाइनेंशियल बर्डन नहीं है, और जो स्टूडेंट्स हैं, जो हॉस्टल में जो गर्ल्स हैं, उनके लिए भी
अलग से कहीं होगा. देखिए इसमें P2 पढ़िए.
जी जी. भोजन व्यवस्था हेतु द्वितीय निविदा ही सूचना
जनजाति कार्य विभाग अंतर्गत संचालित.
जी. जनजाति कार्य विभाग अंतर्गत संचालित शासकीय आदिवासी कन्या आश्रम मांडव विकास खंड नालचा जिला धार मध्य प्रदेश में संचालित आश्रम में निवासरत 275 छात्राओं बालिकाओं वर्ष 22-23 हेतु शासन द्वारा स्वीकृत राशि समय समय पर परिवर्तन शिष्यावृत्ति के दर पर.
शासन द्वारा स्वीकृत राशि.
सर, इनको दे हैव टू डिस्क्लोज हाउ मच इज द अमाउंट with all fairness, with principle on the fair play. They have to disclose. It is not something like that कि आप उसको कोई एक जो टेंडर में कोई वो अमाउंट डिस्क्लोज नहीं है, आप उस पर मेरा वो डिसमिस करें. And I am the sole bidder. I am the.
What is the date for opening, etc.?
Sir, that has been gone. जी, ये 29th of November.
Whether you applied in pursuant to the second NIT or not?
Sir, I have.
You have applied. What happened?
Sir, it is ये तो अभी 29th of 11 तक तो डिपॉजिट करना था. फिर इसके आगे का इन्होंने शेड्यूल नहीं दिया है कि कब ये ओपन करेंगे, कब ये कमेटी के सामने कंसिडरेशन के लिए रखेंगे.
And P1 is issued on what date?
Sir, P1 was issued. The date was not mentioned in that P1 note sheet, but it was uploaded. इसमें जो डेट लिखी है वो है 23rd of September 2022. जो लास्ट में जो सिग्नेचर है CEO के, उसमें सर वो डेट उसमें मेंशन है. Otherwise in entire P1 no date was mentioned. ये 23rd of September. ये नोट शीट
एक सिग्नेचर में डेट दिख रही है.
बस वो एक सिग्नेचर में डेट.
You have already participated in pursuant to the.
Subsequent NIT will be subject to the outcome, final outcome of this petition which shall not.
No, what we.
Sir, because of the reason,
We
they have to discuss it. With all fairness, they have to mention it.
Have you
Otherwise, it
made
will
any
be
date?
endless process, sir. It will be endless process. How can any?
No, but you have applied in pursuant to the You waited for issuance of the another
No,
NIT.
it is not like that, because I have specifically mentioned in my petition that this note sheet was never communicated to me. And since it was uploaded to the website of the government, I took the the copy of from this website only.
We give you liberty to make a representation that will be decided by them. They will pass a regent and a speaking order.
Rather than
You have already participated. One side you are participating, other side you are asking for stay of the same proceedings. It seems either you have got the idea that your tender will not be accepted.
So because of the reason,
Why did you?
Otherwise what will happen, sir? अगर मैं उसमें participate नहीं करता, so I am not in the position to take the chance.
No. When did you come to know about P1? Have you stated in the application?
Sir, basically, I came to know about the second tenders. When the second NIT was issued, I came to know that my earlier tender was rejected. Then I took the copy from the website.
Yes. It's a decision by a committee that.
By the committee, it was never communicated to me.
Yes. We will say that.
Yes, sir.
Sri Padmanabh Saxena, letter counsel for the petitioner. Sri Mukesh Kumawat, government advocate for the respondents on advance notice. In the instant petition, a challenge has been made to the fresh NIT dated 7/11/2022 issued by the respondent number 4 inviting the tenders for providing catering services. Full stop. देखिए prior to the said NIT, the respondent number 4 had issued an NIT for providing catering services to 275 resident girls students of government tribal girls Ashram Mandav block Nalcha district Dhar MP through online mode. The petitioner participated in the bid and submitted his tender. Full stop. It is the case of the petitioner is that the petitioner did not receive any information from the respondents about his bid. Full stop. He came to know about the decision of the committee annexure P1 recently when the second NIT, fresh NIT is issued. Full stop. His previous tender has been rejected by the committee on the ground that the rates quoted by the petitioner per student is higher than the rates which are being provided by the state government. Full stop. It is argued that in the NIT, the respondents have not mentioned about the rates fixed by the state government, fixed and sanctioned by the state government per student, and therefore the decision of the respondents rejecting the tender of the petitioner is arbitrary and the process adopted by them is not a fair and transparent process. Full stop. लिखिए the fresh NIT, as upon perusal of the record, it is evident that a fresh NIT has been issued on 7/11/2022 and the last date for issuance of the tender was 14/11/2022 and date for deposit of earnest money was 29/11/2022. Full stop. It is submitted that in pursuant to the fresh NIT, the petitioner has also participated in the tender process. Full stop. After hearing learned counsel for the petitioner and taking into consideration that the petitioner has already participated in pursuant to the fresh NIT dated 7/11/2022, we are not inclined to entertain the present petition. The present petition is disposed of with liberty to the petitioner to submit a representation before किसके पास जाएगा कलेक्टर?
So ये committee के सामने जाएगा, because the committee has considered the all this.
कलेक्टर जाता होगा कमेटी, कमिश्नर टू दी कलेक्टर, इसमें पार्टी नहीं बनाना। अरे नहीं, वो कौन डिसाइड करे? आई थिंक कि ये सारी प्रोसेस कलेक्टर को डेलीगेट करते हैं टू सबमिट ए रिप्रेजेंटेशन बिफोर द कलेक्टर ट्राइबल वर्क धार विद इन पीरियड ऑफ कितने दिन में करेंगे?
7 days, but my request is they will decide my representation before finalizing the second.
वो कर देते हैं विद इन पीरियड ऑफ, और जल्दी कर दीजिए कि आपको रिप्रेजेंटेशन विद इन 7 days फ्रॉम टुडे, एंड इफ सच रिप्रेजेंटेशन is submitted before the said authority, he shall consider and decide the representation of the petitioner expeditiously by passing a reason and speaking order before finalizing the before finalizing the tender in pursuant to the fresh tender notice 7/11/2022, if not already finalized. With the aforesaid, the writ petition is disposed of.
My lord, I pray for adjournment. I pray for adjournment. Senior is not available.
Senior is not available.
Yes, my lord.
क्या आपका your name?
My name is Rohan Sundecha.
Rohan
Sundecha.
Rohan Sundecha.
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 Yes, my lord.
Sri Rohan Sundecha for the appellant Sri Sharma, government advocate for the respondent state Sri Vijay Gulani for the respondent number 2 on behalf of Sri VP Khare. At the request of counsel for the appellant, case is adjourned.
My lord, pray for next time. Kindly keep it next week.
What's your good name?
Abhilesh Verma.
Sri Akhilesh.
Abhilesh Verma.
Sri Abhilesh Verma for the appellant on behalf of, आपका वकालतनामा नहीं है, on behalf of Sri Piyush Srivastava for the appellant Sri Sharma, government advocate for the respondent state Sri Alamgir Khan for the respondent 5 to 30 at the request of counsel for the appellant. Case is adjourned. Yes.
This is a bunch of matters in which the RBI circular to classify accounts as fraudulent is under challenge. And was in my case in 39, the pleadings are complete. I've even filed a rejoinder to the bank as well as the RBI.
Item number 39.
39. No, this. Yes, Mr.
Why this is listed?
Sorry, Mr.
This is listed before special bench?
Yes, Mr. It's before special bench, before your lordship bench.
This doesn't go before the regular bench?
No, it doesn't.
Last time it was listed before
Justice Abhyankar Saab's bench, and today it's listed before your Lordship's bench, before the special bench. Raj, just sorry.
Just a minute.
Yes, please.
As a question,